Hi, my name is David Fraser. I'm a privacy, internet, and technology lawyer with the Canadian law firm McGinnis Cooper. I also teach internet and media law at the Schulich School of Law at Dalhousie University. I was contacted earlier this week by someone who had nice things to say about a couple of my previous videos, particularly the ones about law around photography and videography in public places, and the one about photographing or recording the police. In addition to saying nice things, which was very kind, they asked about the legality of a police department or a municipality banning the use of cameras in police stations. They said they'd heard of at least a few places in Ontario that have purported to ban still and video recording, and asked about the charter. I think that's an interesting question, so in this episode, I'll look into the particular question. The answer depends on a number of sub-questions, which I'll get to in turn. The first question is, are the police or municipality subject to the charter when they do this? If they are, is this a prima facie infringement of Section 2B of the Charter of Rights and Freedoms that guarantees freedom of expression? If the answer to that is yes, then we have to ask whether it could be justified as a reasonable limit on that right under Section 1 of the Charter. And I think that's where it'll get interesting. I'm of the view that yes, it does violate the Charter, and I'm not convinced that it can be justified. So let's run through the questions in greater detail. In my previous video, I said that the lawful occupier of premises can put conditions on entry into those premises, as long as they're lawful. You could say no shirt, no shoes, no service, or no skateboarding. Somebody who knows about those conditions for them going onto the property, then goes onto the property, does that. When they do that, they're trespassing because they've gone beyond the terms of their invitation. Public property and public-owned properties are a bit of a special case. Two examples I could find are the city of Peterborough and the city of North Bay. For North Bay, apparently there are signs posted in the entrances to the police station saying that photography is prohibited. If you violate that prohibition, you're considered trespassing and you'll be asked to leave under the Trespass to Property Act. In this article by Chris Dawson of the Bay Today, the spokesperson for the police department said the policy was adopted to protect the people who work there. Quote, the background behind it is there's a bit of a movement across Ontario by some groups that have been taking videos and photos of employees as they come and leave work, he explained. It is intimidating and is something we don't want to subject our employees to. Shant says there's one case involving that situation before the courts where someone was filming one of our employees as they were on their properties. Here's an interesting quote from their spokesperson, which I'll touch on later. Of course, we do realize that the media is often present at our police station, and we have a close relationship with the media, he said. Quote, it is essential for them, the media, to be able to film or take photos, so they are an exception to this policy. But generally speaking, we no longer allow people to come into our building or onto our property and take video and pictures. So that's North Bay. Let's look at Peterborough. Joel Kovac of the Peterborough Examiner has a pretty thorough article on the subject, which quotes from the chief of police. It seems to work the same as in North Bay. The police in Peterborough have put up signs prohibiting photography and videography at the police stations. Interestingly, there's a different justification. The chief says this was prompted by an incident in August 2022 when a group of wingnuts went to the Peterborough police station purportedly to make citizens' arrests of some police officers. Obviously, that didn't end well for the wingnuts. But not surprisingly, in 2022, it was recorded by everybody present. This is from Joel Kovac's article. Several social media videos shot and shared at the scene by Didelot's followers showed one supporter being dragged into the station by police. This incident was unprecedented, Chief Bett said, going far beyond the way citizens may sometimes use their phones to take video of police on duty, and it put both officers and civilian employees at risk. As a result, Bett said in an email, it was recognized that prohibited activity on, around, or in the police station needed to be made clear and signage clearly visible for all. They also justify it in this manner. Members of the public come to the police station as a place of safety to report crimes, be interviewed about crimes, or address issues of an extremely personal nature, Bett said, and the police must provide them with as safe a space as possible. This prohibition is purported to extend to their parking lot to, quote, protect the identity of all persons attending at the station to report an incident, unquote. The chief of Peterborough Police also thinks police have an authority under the city's trespassing bylaw to prohibit photos and video, and that, quote, the police station and grounds are recognized as critical infrastructure that must be maintained for the safety of the entire city. Now, I read that bylaw. I didn't see what he was getting at. So the first big question is whether the charter applies to policies made by municipalities. I don't think there could be any doubt. There are loads of cases where individuals and businesses have challenged bylaws and municipal policies for allegedly violating the Charter. One of the most recent Supreme Court of Canada decisions was a charter challenge to a municipal school board. I have no doubt that the decision or policy of a municipality or police chief like this is subject to the Charter. So the next question is whether the Charter is engaged. Does a policy prohibiting photography and videography in a police station violate Section 2B of the Charter of Rights and Freedoms? That section reads, 2. Everyone has the following fundamental freedoms: freedom of thought, belief, opinion, and expression, including freedom of the press and other media of communication. We're focused here on freedom of expression. Note that freedom of expression includes freedom of the press, but it's not a right that's enjoyed just by the press, but by everyone. So this question about banning photography and videography in certain places has been before the courts before. There are a series of decisions from Ontario in the late 80s and early 90s called Squires, in which provisions of the Court of Justice Act that prohibited photography and videography in and around courthouses was challenged. Not surprisingly, it was challenged by the media, but of course this is a charter right that applies to everyone. In that case, the majority of the Ontario Court of Appeal held, quote, "The freedom of expression enjoyed by television journalists, such as the appellant, is the freedom to film events as they occur and to broadcast the film to the public. If television journalists are unable to photograph persons entering or leaving a courtroom, their freedom of expression is curtailed. I agree, therefore, with Justice Tarnopolsky that Section 67 sub 2 sub a sub 2 infringes the freedom of expression conferred on the appellant by Section 2B of the Charter," unquote. So here you have the highest court in Ontario saying that it violates Section 2B of the Charter for a law to say where someone can film and where they can't film. That's exactly what the North Bay and Peterborough police policies are saying. There's an interesting decision from 1989 where anti-sealing activists challenged a federal regulation that prohibited people from being within a certain distance of where seal harvesting was being done. The activists wanted to film and photograph the harvesting of seals and wanted to get the media out there to spread their message. But the half a nautical mile restriction prevented them from doing so. The Federal Court of Canada and then the Federal Court of Appeal determined that this access restriction violated charter-protected freedom of expression rights, even though the regulation said nothing about expression. It just had the effect of curtailing this freedom of expression. So far, it's 100% clear to me that the charter applies to the police of North Bay and Peterborough. And I don't think that there's any doubt that the policies they've adopted violate Section 2B of the Charter. What remains to be considered is whether this policy can be upheld as a reasonable limitation prescribed by law under Section 1 of the Charter. I'm not sure it's a slam dunk in either direction, but I'm leaning towards it not being justifiable. In order for something like this to be justified under Section 1, we have to use something called the Oakes test. In order to pass the Oakes test, it has to be 1, prescribed by law, 2, it has to have a pressing and substantial objective, 3, the means chosen by the government actor has to be rationally connected to that pressing and substantial objective, 4, it has to impair the affected charter right as little as possible, and 5, the ultimate balancing of positive effects on the government action versus negative effects on the charter right has to weigh in favor of the government action. If the government action fails any of these things, it fails to survive the Section 1 analysis. I can't find a copy of any of the policies of either North Bay or Peterborough, but I'll assume it would probably be found to be prescribed by law. I do know, however, that vague or confusing laws, regulations, or policies can fail the prescribed by law part. The big question is, what is the objective of the policies, and is it pressing and substantial? The case I mentioned earlier about the law prohibiting filming and recording in courthouses in Ontario was upheld as a reasonable limit, where the objective was to maintain the calm, quiet atmosphere which is essential for the proper administration of justice. It was also to protect unimpeded access to and from the courtroom by participants in court proceedings. What's notable is that the majority of the Court of Appeal said that the claim of protecting the privacy of people in the courthouse would not be a sufficient objective to support the prohibition. The court did also note that clients and counsel often confer in hallways outside courtrooms, and the presence of videographers would intrude on this, which is kind of privacy related. In any event, privacy for police. So if this is a substantial and compelling issue that needs to be addressed, we ask whether the means of doing so in these policies is rationally connected to the issue. And I think it would pass this one. If the issue is the invasion of privacy of members of the public by recording their comings and goings to the police station, prohibiting that recording is going to be rationally connected. I think the policies would likely fail at the minimal impairment and overall balancing stages. At this stage, the measures taken have to impair the charter right at issue as little as possible. We also get to consider alternatives that will accomplish the objective without harming charter rights. A categorical ban has the effect of preventing otherwise lawful recording that has nothing to do with the privacy of the public. It prevents people from recording what could otherwise be completely newsworthy. For example, when the people went to the Peterborough police station to make their bonkers citizens' arrests, which the chief says is what triggered this policy, that was newsworthy. There were mainstream journalists there recording, as was at least one well-known citizen journalist. A lot of the footage used by the mainstream media was video captured by people who were there, who recorded it, and who then shared it on social media. Newsworthy events take place at police stations, some more exciting than others, and this categorical ban would preclude reporting on them. It also undermines police accountability, and I don't think that North Bay's exception for the media saves it. If their real concern is people who actively interfere with the normal operations of a police station by aggressively recording, the policy could be tailored to that mischief. But it's not. Overall, I think this would fail at the minimal impairment and ultimate balancing parts of the Oakes test. So at the end of the day, I don't think that these policies are consistent with the Charter of Rights and Freedoms, and I don't think that they could be justified as a reasonable limit on that charter right. So then what? I don't suggest going to the police stations and violating the policies to create a test case. I would suggest going through the traditional political channels, like City Council or the police oversight bodies. If that doesn't work, one could make a challenge in a superior court looking for a court declaration that the policies violate the charter and that they're of no force in effect. I hope this has been interesting and useful. I try to put out a new video every few weeks, so if you're interested in this sort of content, please click the like and subscribe buttons. Also leave a comment if you have any questions or if you have any suggestions for other topics to cover. And of course, feel free to share this with anyone who you think may be interested in hearing about Canadian tech and privacy law. Thanks for tuning in.